כן, פתחנו, אנחנו עכשיו הופכים את כולם לפוסט.
אוקיי.
את רוצה שאני אשאר איתך פה בינתיים? אוקיי. אז אני כל הזמן חוזרת אלייך מהמשרד שלי יש שלך, בסדר?
אוקיי. בסדר.
ביי.
לא ברור לי מה הולך פה. מתי שומעים אותי?
כן, שומעים אותי.
שומעים רק אותי, כי צריך לשמוע גם את קונה.
Hello.
Hi, Connor. Okay.
Hi. Yeah, I wasn't in as a participant. Hang on. Let me,
yeah.
where's
Just the two of us.
where's my video?
Now.
Where's my video? Can people turn on my video?
I think you should be able to do that.
I'm trying. I have mute and I don't seem to have an option to get on the video. We should have done a test.
Really?
I'm being promoted. Join as a panel.
Yeah, okay. And Ifad also has to come in now because she's going to say some opening remarks.
Okay. Unable to start video because the host has stopped it. Can you contact her?
Yeah, well, I think she can hear us.
Start video. Here we go. Hello.
Okay, great. And we need Ifat as well.
And well, we only have 40 minutes, so that's good. I am.
Okay.
I need to jump, at.
Okay, great. Here's Ifat. So Ifat will say a few words and then we'll start. Other panelists, you'll be added in, I think, a bit later. So Ifat, you're on mute. Okay, good. Okay, welcome Ifat. So go ahead.
Okay. So hi Yael, hi Kona. I will switch to Hebrew to say a few opening remarks for the whole forum. It's a Biomed Forum of the In-House Council, ACC. שלום לכולם, שמחה לפתוח את כנס הביומד בנושא מניעת סכסוכים בהסכמי רישיון. בעולם הביומד יותר מבעולמות אחרים, ההסכמים והקשר עם האקדמיה הם מאוד מאוד חשובים. בכל חברה, כמעט בעולמות הפיתוח, יש הסכם מהותי כזה שהוא מאבני היסוד, תמיד חוזרים אליו. כדאי להכיר את כל הניואנסים, כדאי לדעת שההסכמים האלה הם לטווח ארוך ולא יכולים לכלול את כל הסצנריos שיכולים לקרות בפועל. זה בעצם הסכם שחוזרים אליו תמיד בצמתים מרכזיות ותמיד בוחנים אותו בדיו דיליג'נס, ולכן טוב שאנחנו כאן ומצליחים לשמוע מפעם לפעם את התובנות וההתפתחויות. אני חושבת שהארגון היועצים המשפטיים ופורום הביומד זו הזדמנות טובה להחליף דעות, ללמוד, להתעדכן. מי שעדיין לא חבר מוזמן לפנות, ותודה ליעל ולכל הפאנליסטים, שיהיה לנו בהנה.
Great. Thank you very, very much, Ifat. It's a pleasure to host this forum again, even if it had to be virtual this time. I know a lot of you from both sides of the table. As you may know, I'm a transactional lawyer. I had the corporate and licensing group at Pearl Cohen Tzedek, lots of Baratz. So while, again, as I mentioned, I'm a transactional lawyer, the scenarios of disputes are often part of our world, unfortunately, whether it's even argumentation during contract negotiation or afterwards. I had the wonderful opportunity of meeting Kona within the framework of an international lawsuit. Once the part, which Kona helped mediate, she was instrumental in helping the parties to reach a settlement. And I was brought in actually to paper it. It was quite complex. So I managed to have a close look at the added value of mediation. So maybe Kona will introduce herself and we'll take it from there.
Oh, great. Can you hear me?
Yes.
Testing. Hi, how are you? Greetings from Boston in the United States, where it's a little bit earlier than it is there. Thank you so much for this opportunity to speak to you. I feel your pain. I was at Inside Counsel in a number of life sciences companies for many years. I started out with Ciba Geigy, and then I moved through a merger with Sandoz over to Novartis. I worked out of the United States and in Switzerland, and I began life as a litigator, so I knew what happened when disputes occurred. And as I went through my life as Inside Counsel in the United States and abroad, I learned how to try to avoid those disputes. And now I've been a mediator and an arbitrator. I do about 50-50 in life sciences, healthcare, and other technological cases, as well as general commercial disputes. You know, Yael, would you like me to talk now a little bit about setting the table and some of the various forms of dispute resolution? Okay,
Go ahead.
I'll just zoom right into that, so to speak, no pun intended, about our forum. If you walk away with nothing else from our talk today, we're going to be talking a little bit about top 10 disputes, top 10 problems that come up in licensing and transactions, particularly focusing on biomed, your areas of expertise. I thought it might be helpful to set the table with a little discussion of the dispute resolution continuum. As Yael aptly noted, when you walk into a transaction or a contract, you know, we're lawyers, we're the voices of doom, right? But it's a good thing. It's a good thing to be a little bit pessimistic when you walk into a transaction and you're drafting it, because there will be disputes. If you accept that basic principle that there will be problems and disputes and misunderstandings, it's a healthy way to look at how to draft a contract and to build in mechanisms that will help you avoid the L word, as I like to call it, litigation, which is just about the worst possible way to resolve a dispute. And there are many things that you can do to keep yourself from that abyss of expense. Now, look, I'm a United States lawyer, so it's worse here than, possibly than in other places. But if you walk away with nothing else, I want you to understand you're never going to mix up mediation and arbitration again. And I'll explain that in the context of the dispute resolution continuum. The first thing, though, to do, if you accept my premise that there will be disputes and you will have stress and conflict and misunderstandings and misalignment with partners, despite all your best efforts to draft a clear contract, which is, of course, the number one thing to do, is you take a step back and you think about what are my tools to prevent myself from getting into litigation. And the number one tool, and this is against my interest because it means you would never hire me as a mediator or an arbitrator, is what I call self-help. What are the tools that you can do working with your companies and your clients inside to prevent disputes from happening in the first place? Dispute prevention, that's become very hip in the alternative dispute resolution or ADR community to talk about dispute prevention instead of dispute resolution. So I've already hinted at one. The first thing is draft a clear contract. As inside counsel, you know your clients just want that contract to be done. And they don't really care about the indemnification clause. But one of the things that I worked very hard to do when I was inside counsel, and I know you do too, is go out for beer or whatever, create a relationship with your clients that makes you approachable so that they will call you and give you the time you need to spend drafting a clear contract, because that's the number one way to avoid disputes, is to have a contract that everybody understands and that will make it very difficult for your partner to create an ambiguity or an argument. So that's number one. Number two is you can build measures into your contracts that help deal with disputes as they arise. One of them is very common in pharmaceuticals, started becoming very fashionable in the 1990s. That's how old I am. Alliance management. There's a whole professional group now devoted to this craft of alliance management. Now, an alliance manager is, it's common in tech contracts. It's an employee of each side. They're not a neutral, but an employee of each side whose job it is to manage the alliance management. They surface issues, they identify problems with committees, they try to spot issues that are going to mature into a dispute or a misunderstanding. And ideally, they have the ear of the top executives who are in charge of the alliance, et cetera, et cetera. So alliance management, there's lots of website materials and resources that deal with this thing. It's also called relationship management. It's worthwhile having those people. If you've got a big, significant alliance, it's worthwhile having that tool, that view from people on your side of the fence, just working to make sure that disputes don't happen. And there are also committee structures, how the alliance or the partnership or the relationship is governed, joint development committees, joint commercialization committees. How do you resolve disputes or ties? How do you break deadlock? That's a science in and of itself. But these are all self-help tools that you can build into your contract that mean you never have to hire me. You want to hire Yael because she's going to draft that clear contract for you and keep you out of your dispute in the first place. And then if, despite all of that advice and all of those things, you do end up in a dispute, I recommend always having a contractual requirement to mediate. I'm just going to put that out there. We don't have a lot of time today. I could talk about that for an hour or two. You'll have my contact information. I'm happy to talk to you about why that's a great idea. But mediation is quick. It's non-binding. It has a great flexibility in terms of what kind of remedy you can have for your client. In litigation, you have a winner and a loser. In arbitration too, which I'll get to in a minute. A winner and a loser. in mediation, there are all sorts of creative solutions, including really, in effect, renegotiating a contract that has just not worked over time with the help of a skilled mediator who knows the field and who has a transactional background. It's really very flexible and creative, and it doesn't have to take a lot of time. People say, oh, but if it's required by contract, really people have to be willing to come to the dance to mediate, but a skilled mediator can help bring people together in the first place. And there's one psychological barrier to settlement that is key to understanding the value of having a third party come in as a mediator. Many people say to me, oh, Kana, I don't know why we should hire you, because we've been trying to resolve this dispute ourselves for 2 years. I hear this all the time. And I'll show you the letters. I'll show you the letters. We've gone back and forth and back and forth, and we're completely stuck. Well, a third party coming in who has knowledge in the field and knows life sciences or knows tech can come in and help the parties kind of come out of their foxholes and take a fresh look at the dispute, dust themselves off and say, okay, let's walk away from our 2 years of letter writing, and we're going to take a fresh look with the help of a knowledgeable neutral who's going to help us evaluate our positions. And there's one psychological barrier I want to mention to settlement. It's called reactive devaluation. When you're in conflict with somebody, you stop listening to them. Just think about your spouse, if you have a spouse, or you're a significant other. When you're mad at that person, are you really listening to them? You're not really listening to them. You hear what they say, but you reactively devalue it because you're in conflict. And when you perceive somebody as the enemy, you stop listening to them. But if you bring in a third party neutral, and I always say to people, each of you are paying for half of me, right? So I'm neutral, I'm here to listen, I understand what you're saying. But when I make a suggestion about a possible solution as the third party neutral, that the person in conflict is listening to me because I'm not the enemy, right? So that, just think about that. That's the value of bringing in somebody, even if you think you've done everything you can to resolve it. And now I'll get to arbitration really quickly. Well, wait, Yael, you were telling me when we were talking about this, that mediation, despite my recommendation, is not very popular or not as common in Israel. I just wondered if you wanted to say a few words about that.
Well, yeah, we don't usually see it built into contracts, even international contracts. What I do see are step-up mechanisms where if the parties can't reach an amicable solution within a certain amount of time, then the dispute will be brought to, let's say, the CEOs or division heads in an attempt to settle them. But I actually can't recall seeing a firm undertaking to enter into a mediation proceeding. And I wonder, is it really that prevalent in the United States?
It is, and I'll make a confession about that. US style litigation with its attendant discovery, especially e-discovery, and the prospect of that is so horrible that it's sort of driven people to mediation. It's no accident that in the United States, mediation has advanced on many fronts and become very developed. And I think it's because of how horrible it is to end up in US courts and how long it takes about, even in federal court, as opposed to state courts, which are sometimes slower. In federal court, I think the stats are that it takes about 27.2 months to get to trial. So, I mean,
that's not a lot by Israeli standards.
Okay, well, all right. Well, see, then
Yeah.
there's a reason to mediate anyway. But I think also it's just not understanding it, or the idea that if somebody suggests mediation, that it's a sign of weakness. But see, that's the good thing about it being in a contract. If it's in the contract, somebody doesn't have to raise the idea, right? It's not a sign of weakness then. I've seen waterfall or escalation clauses like you talked about. It goes negotiation with executives, which is good because it takes it out of the hands of the people who are fighting with each other lower in the company, right? So you get somebody who's sane and not welded into the dispute. Then mediation, and then arbitration or litigation. I've seen those. But I just from my perspective, I've been a global general counsel. I've been a general counsel in the United States, a litigator, and now a mediator and arbitrator for 10 years. I'm telling you, it's really worth considering, especially in your more significant contracts, to give the opportunity to people to hit the pause button. One final word on arbitration. Arbitration is, as a mediator, I have no power to make anybody do anything. I have the ability to persuade, but it's really all about making sure that the parties come up with their own solution. It's completely voluntary. As an arbitrator, it's very close to litigation. I'm a private judge. I can't talk to the parties offline. I'm making a final decision, and an arbitration decision under the New York Convention is final. I mean, it's really not appealable. So I had a boss once, a Scottish CEO boss of a business for which I was the general counsel. I'm not going to imitate his accent, but he said, Kana, I'd rather lose quickly than win slowly. He liked arbitration, even though he knew that he wasn't going to get a chance to appeal an adverse result. At least he was going to get it more quickly, which is true, in an arbitration setting than in a litigation setting. And there's ways to be flexible about the process, especially with a knowledgeable arbitrator who can help you choose experts. And it's a lot more flexible than litigation. So I recommend that over litigation any day. So that's your dispute resolution continuum in 52 seconds. I'm just kidding. It's not, I spent more than 52 seconds, but we could talk about this for a seminar all day. But I'm just trying to encourage all of the Inside Counsel to think about self-help first, put mediation clauses in, even though it's not normal in your world, and seriously consider arbitration. I'd be happy to talk about any more of those modalities offline with you if you want to just send me an email. So that's it. How about top 10 disputes?
Well, yeah, okay. Just before that, just to complete the picture, I think that there are more and more mediations in Israel, but usually they are court initiated. Again, they're not a result of a contract, but rather the parties reaching a court. Courts are very congested. I think maybe I think maybe we may even win the contest of where it may take longer. And this is a measure that the judges often use to try to get the warring parties out of the courts. I'd also like to say another thing in this context, that for some reason, Israelis also easily agree to New York law and international contracts. So obviously governing law is a factor when you're talking about arbitration in particular, usually, which is the governing law, or any other international contract and disputes. And I think that while it don't see many alternatives, I think that Israeli lawyers need to keep in mind that there's a big difference between Israeli contract law and New York contract law, in the sense that New York contract law doesn't recognize the concepts of good faith in implementation, in negotiating and implementing a contract, as a reason for opening up a contract. So a lot of Israelis would be very disappointed to see a court strictly adhering to what's written there and ignoring behavior before enduring to a certain degree. And I think it's just something that everyone should keep in mind.
Yeah,
Okay.
I mean, the only exception to that is in New York, they'd like you to stick to your contract as written. You run into the four corners of the agreement to try to figure out what the party's intent was. If you can show an ambiguity, that's called the parole evidence rule. But if you can show an ambiguity, you can bring in pre-contractual stuff, but there's usually a merger clause at the end. So it's hard. And there is something called the implied duty of good faith and fair dealing, but that people like putting on my arbitrator hat, I'm very skeptical of those sorts of claims, because it means that somebody is trying to get something in the contract that isn't there, right?
Exactly.
So, and the courts interpret that very strictly.
Yeah, so that brings us back to the fact that that was mentioned before, is that it's best to craft contracts clearly and cover all the eventualities to the extent it's possible. So maybe now we'll really move on to the issues that we identified, where the most potential there is for disputes. And the first one is to clearly identify what you're licensing. It's important for the licensor, it's important to the licensee. It becomes more and more complicated, for example, when you have a mixed patent and know-how license. To my experience, there's always a lot of neglect when it comes to ironing out what the know-how is. It becomes more complicated if you have a contract where you have only know-how, which is much more elusive, and also if they're proprietary materials, because if, for example, if a company develops a whole product around some kind of proprietary cell, then even if the rest of the technology that they license in isn't worth anything, they're kind of stuck with it. So that's something that also needs to be taken into account. Also under US law, there's the patent abuse doctrine, where if you have a strict patent license, and we won't delve into that today, it also can be subject for a separate seminar, and I've also discussed it in one of our ACC seminars on licensing agreements in the past. But if you have a patent license with no know-how, then in principle under US law, you can't charge royalties once that patent expires. So it's very, very important to map out what the technology is that you're licensing. Kona, you wanted to add to that?
Yeah, sure. Well, I'll just comment on your know-how point. I'm in the JAMS Boston office today. I am sitting in a, it's probably going to end up being a 6-day hearing devoted totally to a massive dispute about whether or not a researcher who gave a license to his know-how should be getting a 2% royalty on 3 pharmaceutical companies later. A product has been approved in the United States, and he wants a 2% royalty on that because he said it was resulted from his grant of a license to his know-how. And what know-how was granted? I'm about to hear over the next 2 days 4 experts testify about what know-how he supplied, whether or not it contributed technologically to this product. It's really helpful to be as specific as possible about know-how. And know-how licenses also, sometimes you give a grant to know-how as an excuse to give royalties after the patent has expired, right? It's,
Yeah.
So, however, people sometimes take that really seriously. It shouldn't be a throwaway, I guess is my point, right? You should identify the know-how, because then people, they get very exercised about that. Anyway, moving right along. I would also say about this, there are technical and manufacturing failures. People get very excited about, things not having come to fruition, but I think it's very important to understand that there will be technological and manufacturing failures. I suggest also, in connection with figuring out what the scope of a license is, that you really work very hard with your counterparty and before the collaboration has started to understand exactly what is being granted. That's it. I started out with the specific point about know-how, but really there can't be enough attention paid to the scope of the license, the field, all of those terms, because it's no accident that this is our #1 source of disputes. I'll just put it that way. Can't spend enough time on this.
Well, the next one is relates to diligence and development plans and milestones that need to be hit. I often found that if there's an agreement and the development program is supposed to be prepared later on during the collaborations, often that doesn't happen. A lot of things that are left for later just don't happen. I think that there aren't enough contract administrators here in Israel, and not enough attention is given to contract follow-up. But it's, on the other hand, it's very difficult to identify development milestones before a project begins. So Connie, you wanted to talk about commercially reasonable efforts and what that means.
Sure. Yeah, why don't we, that's what we're combining. In the interest of time, we're combining some of our top disputes. But yeah, I think research development and commercialization collaborations, and in many other types of partnerships, it's hard to figure out what kinds of diligence obligations to impose on each other, because you don't want to tie yourself down and have the other side be able to tell you how to run the business, right? So we use very vague terms like X party shall make commercially reasonable efforts to develop this product, for example. But what does that mean? There's a lot of case law on it, but it's very contextual. And my recommendation is that, as hard as it is, you have some exhibits to the contract that define what the party who is supposed to make commercially reasonable effort should do as a floor, right? At a minimum, commercially reasonable effort shall include the activities or the budget or some objective metric that is set forth on Exhibit A, right? It forces the parties to really think about that. And on the other hand, it doesn't tie down the other party who wants as much as possible. If you can set that floor, it really helps diminish the number of disputes. And milestones, I had an arbitration, international arbitration under, I think, the ICDR that went for 1.5 years, very expensive. I think each side spent over, $1 million in legal fees each on ambiguous milestone definitions. Again, this is not an accident that this is our number 2 source of disputes. It's a lot of it's drafting, a lot of it's in a reluctance to really commit on specifics. But when you're balancing the advantage of ambiguity and not being pinned down versus the possibility of an ambiguity that you think is good for your client because they aren't tied down, creating a dispute later on, that's the balance. Ambiguity versus, which is good for your client, versus avoiding disputes through clarity. It's just, if you think about it that way, you know where I come out on that. All right,
Absolutely.
number 3.
Well, wait, before you go on, Carmen, I
sure.
just wanted to add 2 things that I've seen, over the past few years, since this is like a hands-on forum. But for example, one of the things I find the most puzzling are regulatory definitions, because procedures evolve. So if in a license agreement you have a milestone that's like commencement of phase 3 clinical trials, if suddenly the product is in a phase 2b3, what does that mean? So, and when is the transition, basically, because that means that it's a smooth transition into, I have a case like that where, after listening to a few regulatory experts, I haven't been able to resolve. So, that needs to be taken into account. And also financial milestones in terms of money that companies are raising. So is it safe, for example? Is it an equity investment? Because a lot of times that's the criteria. So is a safe investment where no shares are issued? Does that trigger a certain milestone or not? I mean, that's a question. Are grants taken into account? Here in Israel, a lot of money is funded, a lot of research is funded through the Israel Innovation Authority. So if you're not clear as to definitions of these triggering events, then you'll have a lot of confusion and dispute later on. Okay, so run on. I see you're more mindful to the time because you have to go elsewhere. So go ahead. The next.
Oh, no, that's okay. No, that's okay. Why don't you, I think this one is a good one. The rights of first negotiation. Why don't you kick that one off?
Okay, yeah. Another thing is, which I found very, very difficult for parties, especially if you're the licensor, is if you, especially if you're, it actually doesn't matter what party you are, right of first negotiation is okay, if it's clearly defined, but a right of first refusal is a cemetery. In other words, like if you grant someone a right of first refusal to something, then you're never going to be able to commercialize it, because no serious counterpart will give you an offer when they know that you have to run on, and because especially in pharma, for example, it's such an effort. The whole process of internal approvals and negotiations, nobody will make that effort if they know that their counterpart is going to first have to go and offer, the fruits of their labor to a third party. So take that into account. In most, it makes more sense to talk about a right of first look, for example, if it's new technology that's supposed to be added onto an existing license, or at the most a right of first negotiation with very, very strict time periods.
Yep,
So that- yeah.
absolutely. And I have a case, I just wanted to make this point. I have a case that involves whether or not an option to license was granted to somebody when it triggered a payment in another contract. And we're arguing over whether or not it's a right of first negotiation, right of first refusal, or an option to license. The document.
But an option would usually mean that all the terms are spelled out.
Right. Well, that's what one party is arguing, is that this so-called right of first negotiation was actually a license because it had all the material terms.
In
attached as an
other words, it was
exhibit.
an option that could just be.
Yes, right. Yes.
I see, just be.
Yes, so all of these, you just be very clear about what you're doing. And if you
Yeah.
don't want to be pinned down to an option, don't have an exhibit that has all of the material terms attached to it. That's all I'm going to say about it. Okay, so number four, our number four top dispute is the scope of the license. We actually sort of touched upon this, or I did accidentally in talking about something else earlier. The definition of field. Wow. There have been many disputes that I have dealt with both as inside counsel and as a mediator and an arbitrator involving what the scope of a license was: a patent license, a know-how license, a distribution license. So it's, I don't need to tell you that sometimes these are very scientific. I'm dealing with one definition of field that is right now in this arbitration that I'm dealing with, which is incredibly vague. And it's just caused all sorts of disputes. Just spell it out. The longer it is, the better, I guess is what I would say.
Yeah, I think that it used to be more trendy to make field definitions. I think we do see it less, and it's also a recipe for trouble, because as we said earlier, when a company starts playing with technology that it licensed in, very often the results are not known. So if you have a very, very narrow field restriction, and in the course of development it comes out that there are other more lucrative applications for the technology, or what is supposed to be the technology, if there's a field limitation that's strict, then the company may even decide to abandon the project. Or in the case of a client that I had, the client said, I wouldn't mind paying this research institution royalties, even though I didn't really get anything from them. But the fact that I have a field restriction means that if I do develop my own technology in another direction, the minute they think it's theirs, I'll be sued for breach of license. And then my advice was, well, then terminate the agreement. So it was like a lose-lose situation, or at least it was a lose situation for the research institution. So that's something that you need to think about. And another thing is also it's complicated because there are patent costs. Then what does one licensee bear it? Or how do you split it between them? What's fair, under the circumstances? And so it can kill incentives in a lot of ways. And also there's always an issue of litigation in this context. Like one research institute in the United States that I dealt with, I was actually stunned because they wanted to control lawsuits against infringers because they had other interests in this technology, and which was very hard for the licensee to accept.
Yeah, right. That's a very good point. And I think the earlier the licensor is in the development process, I think that's very applicable, what you were just saying, to their interest in maybe giving their partners a little bit more leeway, right? That's really interesting. So now we also, I just want to quickly on this number 4, it's not just fields, but territories, geographical territories. Wow, if you're a global company, you can get really tripped up by that. you got to keep a track of these business people running around, giving licenses to various people in various territories and parts of the world, because they can overlap and be very confusing. Enough said about that. I guess moving on to number 5, we did talk about diligence and criteria here, and some of the financial and regulatory milestones. And I guess number 6 also, we talked about milestones. We were very clever, Yale, by mentioning this, but I think that we can't say too much about milestone payments. Did you want to talk about more than once or per product?
Well, I think that sometimes there are arguments whether milestone payment is due more than once.
Yes.
And then also, if it's per product, what is a new product? I think that's something that very often is neglected, because if you have the same product with a different formulation or for a different indication, is that a new product or not? What's the key for differentiation? Maybe a new regulatory approval, but it needs to be said. It could be very costly, if it's not mentioned.
Absolutely.
So that was my point there.
Yes. And then one of my favorite topics, number 7, top dispute number 7, sublicensing income. I've had 5 significant mediations and arbitrations, and that's more than we last talked about this, Yale. I've added to my collection, dealing with sublicensing income. Just a quick level set. Licensor licenses product A to licensee with a right to sublicense to party C. And licensor says, okay, you can sublicense, but if you get any sublicensing income from that party C, you have to give some of it to us. It's usually a pretty low.
That makes sense.
Yeah, makes sense. So there are all sorts of disputes about the scope of sublicensing income rights, because the licensee often puts a lot of effort into developing the product. Let's say it's a university that is the licensor, and the licensee is a commercial party, an industry partner. They'll put work and effort and into bringing the product further along the research, development, and commercialization spectrum. And they'll probably get additional patents too, right? So there's a portfolio of IP that's created by the licensee that goes beyond what the university contributed. And then the issue is, when you figure out what sublicensing income is, should that 2% that the licensor is getting be on 100% of all of the sublicensing income that the licensee gets, or some portion of it? And you'd be shocked, and perhaps you've done this, you'd be shocked at how this issue is just not really directly addressed in many definitions of sublicensing income. Should there be a method to allocate the contribution of the licensee to that sublicensing income stream? What's included? Should there be a percent of a percent? In other words, all I can say is talk about it upfront with the licensor, because this is one of the top disputes that I deal with all the time. And sublicensing, as you said, Yale, a sublicensing income makes sense. It just does,
Yeah, no, I understand what you're saying. And I think it is amazing that it isn't, I guess it's just too difficult to address the beginning, because nobody, is a prophet and can see the whole downstream. Yeah. But what's interesting is, come to think of it, that if you have interinstitutional agreements between research institutions who are jointly commercializing IP, then they often do address that topic of new IP that's bundled together, and how you allocate, and then they usually have some mechanism for solving a dispute internally if they can't reach an agreement. But in licensing, it is kind of short-sighted. It really looks at the IP that's being licensed out. The licensor, just has these very, very wide provisions where it's compensated on any revenue, and the results sometimes are terribly unfair, so to speak, and also lead towards renegotiation of contracts. I mean, I was recently involved in the renegotiation of a license agreement where the licensee, the original licensee would have been out of pocket if it had to pay the license or the amounts due to it,
Oh, my.
because the licensee was willing to pay less. And this is after years of, tens of millions of dollars, if not more, were invested in the project. And just the pie wasn't big enough, and we had to renegotiate and that's not a pleasant situation to be in.
Yeah, isn't the problem with sublicensing is that it comes up 10 years later, right? It's
Right.
really hard to predict the downstream effects of that negotiation. So, one thing you can do is build in the ability to renegotiate if that kind of situation comes up, but let's face facts, it's impossible to predict the future. So that's one reason I think that these things cause so much stress in contractual relationships. That's precisely because it's so far down the trail. All right, so now number 8, we're up to number 8, development reports and audits. Really, I think it's very important to, as I think you said earlier, Yael, not put that contract in the drawer and insist on your rights to development reports, and remember that you have an audit right and take advantage of those rights and read the development reports, because you can so easily get into a situation where you're not taking advantage of the rights to monitor the relationship. And you can see issues arise in those development reports, or if you do a regular audit, it helps. It sometimes creates a little strife, but it helps prevent disputes. It helps issue spot if you are taking advantage of those rights and not putting the contract in the drawer. That's what I would say about that.
Yeah, I mean, because it can be important to both parties and later proving whether, for example, commercially reasonable efforts were expended. Without that real-time evidence, it's very hard to argue later any of these points. Okay,
Yep.
Go ahead, because we're running out of time. We'll
Yeah.
finish it. So go ahead.
Yes, I'm going to run through 9 and 10. Effects of termination. Okay. If you're a transactional lawyer or a contract lawyer or even a litigator, you will have had a chance to focus on the contractual provisions for effects of termination. I have seen so many disputes, both as an inside counsel and a mediator and an arbitrator, about these clauses, which are often underwritten. So if somebody terminates, what has to happen? What are the effects of termination? Those should be long clauses, that they should not be one paragraph. Who has to return what and when? Who owns what? What rights remain? What rights survive? Survival clause. Everybody's least favorite clause. It takes forever, right? If a dispute arises, that survival clause, what obligations survive, it is absolutely going to be in play. Absolutely going to be in play. And that's all I would say about that. Think about the effects of termination. It's one of those clauses where you have to slow your client down and say, I know we don't like thinking about termination, but what happens when the relationship ends? Because otherwise you're going to end up in court or before an arbitrator or with a mediator trying to figure out what the results are.
That's great. Yeah. And I think Liron will expand on this within the framework of the panel, but one of the things that's very, very often overlooked is the issue of joint patents, because a lot of times under license agreements, there is collaboration, there are joint patents. So what happens to those joint patents once the agreement is terminated? Because if the agreement is silent, then the laws of various jurisdictions treat joint patents in a different manner. Who's free to use them? And then who's going to pay for maintenance, for example? There are a lot of issues, and it's something that I also find often overlooked. So, Kona, I want to thank you. If anyone has any questions to Kona, we'll circulate, yeah, she just
Oh,
circulated.
well, no, but you're going to
It's-
circulate it too. Circulate it too. Okay.
Yeah,
All right.
yeah, that's
But
really.
it's like, leaving before the movie is over. We promised them 10, just really quickly, right? That
Yeah, go
I
ahead.
have enough time for that. She's trying to be very, I have an arbitration starting in about 10 minutes, but she's, yeah, it's going to
Okay.
try to be very polite to me and make sure, but just really quickly, number 10
Okay.
is right to publish on confidentiality. Make sure that you are very clear about that, especially in research fields. I know that Yale has had this issue too, because that's something that implicates patent rights, and it's important to make sure that everybody understands what they're able to do, consistent with the obligations of confidentiality in the clause, right?
Yeah. Yeah, that's something that's really hard to also somehow enforce. We had a situation where a discussion was held about confidential information that was licensed in from a research institution, and someone on the board later stole the technology, and this person wasn't even bound by a confidentiality agreement vis-a-vis the research institution. The company went into insolvency, and later, the IP was out there. It's really endless. That's what makes our profession so interesting.
It's so fun. And, I guess the last point to make on that is clients forget that confidentiality obligations have two parts. One is don't disclose. That one they remember. Don't disclose, but don't use for any purpose other than the purpose that it was given. They forget that all the time. So even internally, they would say to me as inside counsel, oh, I didn't disclose it to anybody. I just used it for my favorite project inside. I said,
Great.
don't tell me that. So anyway, look, those are our top 10. Those are our top 10 sources of disputes. Thank you so much for inviting me to speak. I'm going to actually get to Israel someday. Someday. And have a great rest of the conference.
Thank you very much. And again, anyone who writes, in the chat, okay. Anything you write in the chat, we will address. Okay. Yes. We'll summarize the 10 issues for you. No problem.
Absolutely, no problem.
Okay.
All right, bye-bye, everybody.
Thank you so much, and good luck with your arbitration.
I'm gonna go get more coffee now.
Okay, bye-bye. Okay, so that was really, I hope you enjoyed that as much as I did. I'd like to now introduce the panelists. I really hope to God that they're connected. So I now see Hadar Wismowski, who's former counsel, in-house counsel, general counsel to Teva, and has since made an illustrious career with other companies. So maybe when she introduces herself, she'll tell you about that. But she has a very, very wide range of experience in a lot of fields. And then we have Liron Zussman, who's general counsel of Ramot at Tel Aviv University, and Bob Trachtenberg, who's general counsel at ISUM, which is the TTO of the Hebrew University. Strangely enough, I don't see them. So I hope that they're here. I suggest that because I don't see them, maybe Hadar will start with her input as the licensee as opposed to the licensor, since that was her more typical position, I believe. So go ahead, Hadar.
Thank you, Ed. Actually, I was hoping to go last because I'm a little bit rusted in the pharma field. As you mentioned, I've moved away a little bit in the recent years from biotech.
Yeah, but we're not limiting ourselves to that. I think that licensing is really relevant.
Yeah, it's like riding a bike. So I'm so happy to see some familiar names of former colleagues, and I've been with Teva for 10 years until about 5 years ago, mostly general counsel of the global R&D unit, mostly dealing with collaborations with academia, licensing in, a little bit licensing out, and I guess everything that Kona mentioned here was really close to my heart back then. And later on, I moved to telecom industry and now banking. So I've a little bit shifted away, but this is still very close to my heart. So I can start a little bit, but maybe after Bob and Liron speak.
Okay, so wait, so
you have
Liron, are you
anything?
there? I don't see you. Liron? Bob?
I think the host needs to let them in as
Yeah, I apologize. I don't understand why this is not working out. Bob raised his hand. What does that mean? And what about Bob? Well, Bob is not here either. Bob? He raised his hand. Great. Hi. What now? Okay. Here he is. Thank goodness. Okay, we are so.
Okay, I'm here now.
Oh, thank goodness. Thank you. Thank you, Bob. So the floor is yours.
It was interesting. I enjoyed listening to the former speaker. I think that from our point of view, one of the things that comes up a lot is what she was talking about in terms of the company's due diligence in developing the technology. And I think it's true for most TTOs where we're generally licensing out our technology at a very early stage, extremely early stage. And so for us, being able to keep track and follow what the licensee is doing is really important. In all agreements, we require development reports. An argument with the company in the drafting side often is, how often do we get the development reports? They have not, the company, certainly in the beginning, they have nothing to say. I mean, everything is going along slowly. And so they're trying to get, how about once a year? How about once every 2 years? And we like it. We generally ask for quarterly. We're perfectly happy to get 6 months, and we often, depending on the technology.
Quarterly?
Yeah, nobody gets quarterly. It's okay. 6 months. 6 months is we're very happy with. A year we can live with. Again, we also, in a lot of the companies, as I said, are startups. Or not even companies yet. They're entrepreneurs who are, one of their obligations is to raise money within a certain amount of time to establish a company. We often we ask for a seat on the board, which has its own complications, being both a board member and a licensor, or an observer on the board, which is another way of keeping track of what's going on. And if a company is having a board meeting every quarter, which many companies do, then we have our quarterly development reports, essentially. The other piece is, the original template, when I first joined YSUM, we didn't have any templates. So I put together a template with the help of various members of the licensor bar. And one of the things we included was a steering committee, which was mentioned earlier, either by the relationship management committee, a lot of different names. We called it a steering committee, and it would meet again, sometimes quarterly, 6 months, every year, and that it wouldn't be. We made it very clear, because companies never liked it, never liked the idea that they were going to have to meet with us on a regular basis to discuss the development process, and it all, what their usual demand was, it can't have any deciding power. They could meet, exchange information, but if there was a dispute, then it would have to be kicked up usually to the CEO level, which is fairly shallow in most of the, most of the licenses we have. They're small companies, and certainly YSUM is a small company. What we found, however, is even where companies were willing to agree to a steering committee, yeah, in the license, it never happened. And it didn't happen from their side because they didn't really want it in the beginning. And it also didn't happen from our side because the business development people who are going to be usually the people who are assigned to sit on the steering committee, they're overwhelmed, but with ongoing work with trying to get new licenses signed, new deals done. And it was only recently, I guess in maybe 4 or 5 years ago, that we actually installed a relationship manager, sort of a contract manager, but someone who is in ongoing contact with the companies of the licensees, to find out what's going on, to request the development report when it's not submitted on time, because it generally isn't. So the whole process of development, and then we get into another clause that we like to see in the agreement, which is if they miss their development milestones for reasons other than, for reasons under their control. So if the regulatory process slows them down, obviously we can't fault them generally. Or if there's a war in the Ukraine and all their development is in the Ukraine, well, then they get a pass. But if they don't make it, then what do we do? We're very concerned, again, because in different contexts for different reasons about the shelving of our technology, or a company that which happens more, I would say, with larger companies that have a lot of different streams and development projects going on, and what they've licensed from us might have fallen out of favor, or may potentially compete with an internal candidate, and they just sort of leave ours aside, thinking, okay, we'll keep it in reserve. We're very concerned about that. One way we deal with that, at least, is to make sure there's a price involved if they're going to shelve or not develop a technology. We require in every agreement that we have a license, what we call a license maintenance fee. Other people call a minimum royalty, which is imposed when usually at a time in the future that it'll begin where we think or the parties agree a normally developed technology should result in a product. And the amounts are not, they can start as low as $5,000 a year. In some cases, we let them grow for a certain period of time up to 50. We've signed agreements where it's $50,000 a year to maintain the license. And those payments we always allow them to be credited against royalties payable in a given year. So at least if they're actually doing what they said they were going to do and get a product out to sale, the $50,000 or the $30,000 or whatever the amount is doesn't hurt them. But we have a clause in the contract that it ends us in disputes so far only pre-formal disputes where we say, if you don't make the time, if you haven't met your milestones, specific milestones, we can hold you in breach, and that unless the company, there are two versions, either cures it and gets back and meets the milestone within a certain amount of time, we're entitled to terminate the agreement, or what I have recently come to prefer, that they have to submit to us within a reasonable amount of time, short period of time, a reasonable plan, or that we can accept or reject for how they are going to cure the failure to meet the milestone. And that can be, given 30 or 60 days to say, look, this is our fundraising plan, because usually it's a question not so much of development delays caused by the technology. More often, again, with our licensees, they ran out of money, or they never had enough money to begin with, or they don't have the right personnel. That's how we deal with it, and that's I'm pleased to say that we have had virtually no litigation over this. over these things. We've terminated many agreements for failure to develop the things. And that gets into some of the things on the list is what happens after the termination? What do we get back? What does the company insist, or more often, what do the investors in the company insist on keeping? Because often what happens is we're terminating it because the company has run out of money and it's basically being liquidated. We often come into the argument from the investors, well, there are assets in the company, we're liquidating the company, but we don't want you to take back the development results, for instance, what the company developed on the basis of our patents. And we get into a number of different ways of approaching that as well.
Such a,
Well, I mean, one is, one is ignoring them and saying, too bad. That's not as popular with the investors, the stakeholders, as some of the others, whereas we're willing to return development, verified development costs. If you tell us the company spent, I don't know, $100,000 to develop this over the course of 3 years, and we can check. We put in the ability to audit that claim in case we don't, on the face of it, accept it. But there, we will only do that if we take back the development results in order to make the package, the licensing package, more attractive to a new licensor. We say, in the event that we actually relicense your development results and we receive income from that, we will give you a percentage of that income up to, generally, we try to hold the line at 1 time the development costs. Other times companies or their stakeholders insist, no, we want to see something out of this. So we'll go 2 or 3 times the entire development costs. I have to say it's proven a theoretical argument so far. One, because it takes a long time to do any of that kind of thing. We've taken back we've had assignment back of the development results, but even if on the next day we relicense it, it's going to take a long time before we see money. And more often than not, technologies are very hard to relicense. Speaking.
Do you have any people in-house who really have experience in product development? Because I think that is also maybe part of the problem why these steering committees don't work. Because why would anyone want to?
It's true,
right? I mean, I guess
it's beyond that. It's not even so much. Yeah, I think it's one thing that our business development people come from various backgrounds. Some of them have product development experience or have had product development experience, but not that many, and not necessarily in the industry in which they're now doing business development. More often than not, it's just expressed as a general, we don't want the university, and we don't like universities involved in our business. There's an approach that academia is just that. It's academia. It's ivory tower academia. What do we know about developing products, commercializing technologies, regulatory issues? Because for most of the people involved at the academic level, there isn't any. I mean, I would cite one of our researchers, Kezi Barinholtz, who actually brings a lot of value in the issue of regulatory, because he's had lots of experience with doing that. But even most of our researchers don't, if they could develop a product, if we had the resources to do that, we would do it on our own. We wouldn't be licensing out to companies. We license the companies because they're the experts, or they're purported to be the experts.
Supposed to be, yeah.
They're supposed to be the experts.
Right.
Teva is a good example. We did lots of deals with Teva. Teva is an expert in the development of molecules into drugs. And they didn't like steering committees. They didn't particularly want us on steering committees. And I understand that. For us, the steering committee is not so much a approach to direct what's going on as another way of us monitoring what's going on and keeping our finger in. Because often companies, whether they be big companies like Teva or Novartis, or startups that just don't have the bandwidth, they don't want to, it's not even they don't want to tell the licensor what's going on. They just forget about it. They're like, it doesn't occur to them. It's bad enough they have to tell the investors sometimes what's going on through the board or shareholders meetings. If they can avoid one less reporting duty, they're happy to do that.
Why would you want a director who has liability as a director? I mean, why?
It's something that's actually argued about a lot here. One is that especially when we're setting up a company and we're a shareholder in the company,
Right.
we like to be, there's a natural inclination to be a director. If we're doing a simple license agreement without where we don't have any equity in the company, we don't ask for, and nor do we expect to be offered a directorship. It's only in the not uncommon cases where we are part of the founders group that we're getting founders equity to begin with, that we are often offered or request a directorship. And I can say that many times after the company is set up and is sort of moving on its own, we often will resign the director. We'll waive our directorship right, because it gets you into trouble. I mean, I'm right now in a particular dispute with a company, and I'm limited to talking internally, because the business development person who sits on the board, she has, dual loyalties, dual obligations.
Yeah, it's problematic.
So she's left out of a lot of the internal conversations we've been having, which is not ideal, to say the least.
Yeah.
But we're looking, one, not to have information leaked to the company until we're ready to talk about it. And two, we don't want to put her in an uncomfortable position, both ethically and legally. So, yeah.
Wow. I wanted to also circle back for a minute to what you said about license fees as being, an anti-shelving mechanism, which is, I think at the end of the day, it's a good one, even, and the sums could be, and usually they're not that high, but they could be sort of a thorn in the side of a company, that they're not going to sit on the technology, pay every year for nothing. But I think that another thing that's overlooked in that context is that a lot of times a license agreement will say that these annual license fees are payable over the life of the agreement. Now, if you have a country by country, product by product agreement, that basically means forever. So I think that more attention needs to be given to that provision in having some kind of a cutoff date. Otherwise, it's ridiculous. And then it puts a licensee in the situation where they may want to terminate just to get rid of that eventually. I mean, it just puts everyone in a bad place, I think, and it's something that.
No, we would certainly consider a cutoff, because frankly, if it goes on for 6 or 7 years into a license payments of that license maintenance thing, and there's no product that is being sold to offset it, one wonders why they need the license any longer at all. We would certainly seek to terminate the license mutually on a mutual basis, which has been done. But again, that's part of it. Is you want to sit on the license? Okay, we can't really get into your kishkas enough to be able to determine whether you're really doing what you're supposed to be doing, and it's simply a hard technology to develop, or you're doing things that are incompetent, or you're letting it sit moldering in the corner. There should be the accounting department, or the finance department of the company should say, every year you don't develop this into a product, don't think it's free. You're sitting on, you're paying this licensor $10,000 or $15,000 a year for what? Why?
So then why do so many of the research institutions have such a strong objection to termination for convenience being built into agreements?
We're not asked for it all that often. We've agreed to a lot of agreements have termination for convenience clauses. What would bother me about it is the company it puts us in a situation. I mean, are you talking about just a termination of convenience from the company's point of view? Or
From the licensee's point of view.
If they're paying us minimum royalties and they decide they want to just terminate the agreement for convenience, we wouldn't have a problem with that. I don't think. Again, we don't want it sitting there. We want, our patents are continually aging, like the rest of us, and neither the patents nor we are getting any better as we get older. And so we try to, there's so much involved in getting these technologies out into the marketplace because they are so early, trying to find a group that is willing to take the risk on it and is competent at the same time, so that the risk that we're taking by giving it to a particular group of entrepreneurs is not going to be to our detriment. Because if a entrepreneur takes a technology, sets up a company, and tries but fails in the 4 or 5 years to recruit the necessary people, to get the necessary additional investment, that just puts us 5 years behind with nothing to show for it.
Right. Okay, thank you. And wait, continue. You wanted to say something else?
Oh, yeah, no, and just so we don't like giving companies it just doesn't feel right to give a company, in most cases, just, oh, we're done, we're finished. We let us tell. I mean, for cause, I don't have a problem for
cause is a whole different.
No, forget for cause. I was going to say, the truth is, I generally, when someone says we want a termination without cause provision for convenience, I'll say yes, but I'll make it, the notice has to be a certain, a decent period of notice. We often say you have to continue paying the patent costs for X amount of time after the termination. And if there was sponsored research involved, we also would probably like the sponsored research to go on. We have a lot of obligations, fixed obligations that can't be cut short just because a company decides that they're tired or they've decided to go in a different direction. With those kind of safeguards involved, we're willing to allow a company to terminate for convenience.
Okay, I will not relate to that. Okay, is Liron here? I really feel terrible. I don't understand what happened. So we'll go on to Hadar. So now from the other side of the ring, Hadar, it's your turn.
Sure. I just wanted to zoom out for a second from the specific issues in the contracts, maybe to just say, as a follow-up to what Connor mentioned, why we want to avoid disputes. I mean, everyone wants to avoid them, but it's not only the fees and all the hassle that surrounds them, that's for sure. I think either Yael or Ifat in the opening remarks mentioned it's a sector where we are a reoccurring player. I mean, we meet often. Everyone here is doing licenses all over and over again. If it was Teva with Isum or Amot or Yeda or any other pharma company. First of all, you don't want to ruin your name in the market, either as a licensor or a licensee. If you are perceived as a troublemaker, as a company that nobody wants to license from or license to, that's a big issue. So usually people really try hard to solve this in closed doors rather than to go to a real public dispute. That's one reason. And the other one, Bob mentioned, touched upon a lot termination scenarios, but we are also facing disputes during an agreement, not only when we terminate. And then you really don't want to fight with your partner. Just take, for example, the Copaxone drug for Teva that Teva licensed for more than 30 years from Yeda. There were a lot of, different point of views during development and during commercializations. And neither side wanted to risk this very fruitful collaboration and to fight with the other one, even if we think differently. So it's really very important to try to avoid disputes, either when you build a contract, but the Copaxone agreement was signed in 1987. Nobody really knew it was
1887?
Yeah, it was probably 10 pages long or
It was a
something,
50
right?
pages. I think it was in Hebrew even. If
It
I
was in
remember.
Hebrew, I saw it once,
Yeah.
yeah.
It was one of the shortest agreements I've ever seen, but it was one of the most successful relationships in Israel. I
Hebrew is
guess.
a much more compact language, though.
Yeah, yeah. So really try to avoid disputes, and then I also wanted to touch upon the development plan and the development milestones issues that Connor mentioned as I think one of the high in the top 10 list. People really tend to overlook this when signing an agreement. It's they don't think it's important enough, or it's an annex, so the lawyers don't really give attention to it. Sometimes they focus on the agreement itself and just let the development people draft the development plan annex. It's one of the most important things to take a look at. It's very hard to anticipate reality, as was mentioned here. I mean, nobody can really know what's going to happen down the road, but at least try to forecast things that can happen. So this is really something to put a lot of thought into. I'm not sure I agree with the approach of being very, very accurate and clear. I mean, I understand from a litigator point of view that clarity is important and helpful, but because reality is so unanticipated, sometimes you want to leave some room for flexibility. As Yael mentioned, sometimes a phase 3 is actually a phase 2B, or another phase 2B, or a second or a third phase 2B, or any other things that happen down the road that you can't really expect. So a little bit ambiguity, I think, could be helpful, actually. Of course, it's good to find some balance between clarity and ambiguity. But this is really something important to give a lot of attention to during negotiations. Another thing that happens down the road is unanticipated results or applications. I mean, as life goes on and you start the agreement from one point and then the development evolves, sometimes you occur a situation where you end up with the result of development that either is not covered by the field, because maybe you licensed it only as a drug and then you get a device or imaging or anything else that is not specifically under the field, or even if the field was very broadly described and defined, the commercial terms are not really relevant anymore. So you need to renegotiate the agreement at some point. So, I mean, nobody can really expect this. I mean, you can try to, but there's no bulletproof solution for that.
Sometimes people enter into agreements just because they want to, start utilizing the technology, and they take the risk. I mean, even though, for example, everyone who signs, a net sales onto a net sales provision that includes sales of sub-licensees is taking a certain risk. Because, and very often, and again, as I said, I recently was in the situation where the licensee would have been paying for the pleasure, because they weren't going to be earning anything, and it had to be renegotiated. It was a very painful experience. And
Right.
so I've seen this more than once.
Right. At the beginning of the road, everyone is very eager just to jump in and start and sign. And, we lawyers are, the party poopers, and we want to give thought to a lot of issues that nobody else really cares about. And just,
Well, yeah,
we're standing in their way to sign and start working on the project. But it's really something that that is important, I think. Also, publications that was mentioned here, it's a painful subject. It seems, a little bit a side issue. But I remember a lot of cases where Teva as a licensee was surprised by publications of someone from the academia. They didn't remember that commitment to, show us the publication in advance. A lot of people think about the patent issues and IP issues, where, the publication can hurt us from the IP perspective. That's, of course, very important. But no less important is that sometimes the data there can be harmful to the project. I mean, it's not that we're trying to hide anything, but sometimes the licensor wants to go in one direction with the product, and all of a sudden the researcher is researching something else and disturbs the process with bad data that really is, just a noise in the system, and it takes a lot of attention there just to deal with this and clean it up later. So really important to emphasize the obligation to get approval in advance to the publication itself, to the content, to the real paper. So this is very, very important.
No, it's interesting what you mentioned at the beginning that people don't want to ruin their reputation, but it's funny because my experience, not in the recent future, but long ago when Teva entered into, Teva started out with a bang here on the local market with its innovation group, and there was a flurry of investments in startups and projects, and it really was an exciting time. And then Teva started to become more of an international company, and then and to over leverage itself, and whatever happened there, the next thing we knew here in this little market was that all the projects were slashed. And I must say that I was on the other side of several agreements where Teva was in blatant breach of its obligations, to whether it be investment or diligence, whatever. And all the startups were actually afraid, of taking action, and no one, it's really quite astounding, when you think about it, that not one company that I was involved in ever thought of suing Teva to actually implement, even though, we weren't talking about big numbers.
I think there was one litigation.
There was one of them, or wasn't
one
it
related
wasn't
to somehow Mediating and Polyhill. I think there was a little bit something
there
that was
was?
dragged into court, but it wasn't very big one. But I'm not sure. I don't want to go into any details, but some of the licensors maybe felt that there was a breach, but in most cases, at least, it was just termination. There was a right to terminate, and that's what Teva did. The fact that people were disappointed from that, I can fully understand, but it wasn't against the agreement, or in most cases at least. They had the right to terminate, and that's what they did. They decided to go elsewhere and put their money in other fields, and that was legitimate in most cases. So I can understand the feelings, but it wasn't anything illegal or against the contract in most cases.
Okay, we'll have coffee one day. Okay, great. So I think that I guess, I don't know if this system, first of all, I want to really apologize to Liron and Yifat, who got irretrievably thrown out of the system. Don't ask me why, even though we have a special IT person who seems to have been shipped in directly from Ukraine to handle it, and maybe his thoughts were elsewhere. So I'm sorry about the malfunction, and I hope that all of you
We can take any questions, I guess, if there is any.
If we can hear people, which I'm not sure.
Chat or whatever.
Or through the chat. So if anyone wants to ask something via chat, then this is the time. We'll give you a few minutes. Oh, I don't see any activity. And again, I think we reached the end of our time. We'll give you a 5-minute break to do something else in your free time. So thank you, everybody. And I hope you enjoyed it and found it a good learning experience. And any questions, be free to address any of us directly. Thank you very much. Bye-bye.
Thank you.